Good morning. Welcome to Coffee with CartLaw Alabama. I'm Daryl Cartwright, an attorney in Birmingham, practicing throughout the state. This morning, I'm drinking my craft coffee. It's a coffee subscription that I indulge myself with. It's a throwback blend, a flagship blend of Latin America coffee, smooth and mellow with inviting tones of milk chocolate and caramel. I don't get a commission, but it's a good subscription service and enjoy that every month. Today, I wanted to talk to you about something. I've got a little PowerPoint presentation prepared, so you don't have to look at me the entire time. I'm going to go ahead and share that with you. It's my dynamic duo, the estate planning combination of a Pourover Will and a Revocable Management Trust. All right, here we go. Estate planning, my dynamic duo, the dynamic duo, Revocable Trust and Pourover Will. First of all, Revocable Trust, what is it? Well, it's a document that is designed intentionally to be amendable or revocable, something that can be altered, amended, or revoked by the grantor. Sometimes you hear that called the settlor. The person who creates the trust, generally you, my estate planning client. And what does it do? Well, it does everything that a will might do at the time of death, but it does more than just that. It allows property to be managed during a lifetime if needed, and it also provides a very good, effective means of passing whatever property is in it at death to your beneficiaries, the people you choose, without having to go through probate. What does it not do? Well, it doesn't protect the grantor against their creditors during their lifetime. It doesn't qualify the grantor for Medicaid and doesn't provide any estate tax benefits. You can do things like that with other documents, but when you do that, you lose control and you lose a lot of the benefits of the revocable trust. The revocable trust is wonderful because for all intents and purposes, it's the same as if you still own the property outright, because you do. Now, at death, when the revocable trust when the grantor dies at death, the revocable trust becomes irrevocable if the grantor was the only party that retained the right to alter, amend, or revoke the trust. Now, usually we have a husband and wife, and if that's the case, the spouse, the surviving spouse, whether that be the husband or the wife, usually retains that right to still alter, amend, or revoke the trust, just like they could their own will. The trust at the time of death usually provides for beneficiaries, but the trustee doesn't have to file the trust in probate court. It's kept private. It's not public for everybody to see that wants to. In addition, they're not under the thumb of the probate judge. They don't have to get probate judge approval to do the kind of things that you want your trustee to do according to the terms of the trust. Can you avoid probate? Yes, you can. That is one of the very primary benefits of having a revocable trust. If all of your assets are transferred into the trust or are held jointly with right of survivorship or with a designated beneficiary, there's no need for a probate process at all. It avoids paying attorney's fees to open a probate estate, obtain the necessary signatures, and meet with the necessary people to prepare and file documents such as petition to probate a will. It avoids paying the filing fees associated with probating a will, possibly fiduciary bonds for an executor, although most estate planning attorneys will waive that requirement in a will. And it also avoids paying administrative costs like publishing notice in a legal newspaper. it avoids opening a claims period for creditors to come in and file claims against your estate. It may also possibly avoid creditor claims, the claims of creditors of beneficiaries as well. So you've got beneficiaries and they have some sort of creditor issue. This might be a way to help them out. If the revocable trust is that good, why do we even need a pour-over will, or a will that's called a pour-over will? Well, first of all, what is a pour-over will? It's a last will and testament, just like any other will, but it tells the executor, hey, if I own anything in my estate at the time of my death, just pour it over into the trust that I've created and let the trust take care of it. But why are we even talking about a pour-over will? Doesn't a will have to be filed in probate court? Well, yeah, it does. But a pour-over will, I like to think of as insurance. It's protection. If every asset that you own is transferred in the trust and the grantor, the decedent, owns nothing in his or her name at the time of his death, then the pour-over will won't be used. Well, that's okay. But what if we forget to transfer all of the assets? What if, although we directed an investment advisor, banker, life insurance agent, other fiduciary to change the owner, they didn't get around to doing it? I've seen these things occur. What if we sold an asset and bought another one and we didn't get a chance to transfer the new asset into the trust? What if we had an asset we didn't know about? An insurance policy taken out a long time ago. What if we had an asset created by death, such as a contract right to receive compensation, the sales price sold for something else, or whatever? Well, if any of those what ifs occur, then the estate owns something at the time of death. And if the estate owns something at the time of death, then probate must be opened. Either a testate estate, meaning one with a will, or an intestate estate. So what if you don't have that insurance pour-over will and you end up with some asset in your estate? Well, if that happens, it passes by intestacy. Intestacy means extra probate fee costs, extra hearings, buying an insurance bond from a fiduciary bond from an insurance company, possibly even having property go to someone you didn't want it to go to, because intestacy laws dictate where it goes, and not you, not your trust, not your will, because you don't have a will. And it may even go to a creditor instead of one of your beneficiaries. The pour-over will protect against those kind of things. If the estate ends up having an asset, even though you thought you transferred everything, even though you intended to transfer everything into the name of the revocable trust, if it ends up owning an asset, all is not lost. The pour-over will waive the requirement for a fiduciary bond. It won't require extra hearings because it will be self-proving according to law. It will possibly, this is uncertain, but possibly even avoid creditors because it will tell them to distribute it directly into the trust itself. It goes to the beneficiaries you want in the way you want it. For example, in your revocable trust, you may have a provision for a young beneficiary for their portion to be held in trust for a certain period of time. And this would allow that. The pour-over will just says everything goes to the trust and let the trust take care of it. In any event, that's the dynamic deal, and that's why we use a pour-over will with the Revocable Management Trust. I hope you have a great day and the rest of the week, and thank you for joining me on Coffee with CartLaw Alabama.